many different purposes. Because law reflects the societal conditions under which it operates, significant differences existed among the legal and governmental cultures of the early colonies. As Part 1 shows, Maryland and Massachusetts and the other New England colonies were founded for religious ends, as havens for victims of religious persecution or as models of political and religious rectitude. The religious purposes of these colonies profoundly influenced their early law. Maryland, for reasons that will be explained, quickly adopted the common law, whereas Massachusetts and the other New England colonies turned to the Word of God as a foundation for much of their law. New Netherland and Virginia, in contrast, were founded by trading companies. New Netherland, which succeeded as a mercantile outpost, adopted the Dutch law of its parent company. Virginia initially was governed by military law, but when it failed as a trading and exploration venture and turned to agricultural production of a staple crop, tobacco, it needed different law. Like neighboring Maryland, it turned to the common law, although somewhat more gradually. Thus, by the mid-17th century, 3 different legal systems were in place along the North American East Coast: the common law in the Chesapeake, Dutch law in New Netherland, and law having a biblical foundation in New England. How did the law of these diverse colonies come together? Examination of the theme of how a common legal culture emerged out of the diversity of the initial settlements begins in Part 2, where the second of 4 major themes, the theme of reception of the common law, also emerges. Much has been written about reception, but the writing has been driven by the perspective of lawyers. The focus has been on what parts of English law were received and what parts were not received. Legal writers have paid little attention to differences among the colonies in what law was received, to the temporal pace of reception, or to why reception occurred. Part 2 takes a different approach. It begins with the restoration of Charles II to the English throne in 1660, and with the English conquest of New York in 1664. These 2 events created a problem for Charles. How could he govern his discrete colonies and turn them into a coherent empire when he lacked a standing army, a bureaucracy, and money? The answer that he and James II, his brother and successor, developed was to use the legal profession, which brought the common law with it, as a mechanism for governance. Part 2 examines the nearly century-long process by which the Crown imposed the legal profession and the common law on colonies that did not always want them. The imposition proved successful, at least in part, because of the common law's amorphous nature. Did the common law comprise all of the law of England, including the rules of canon law and equity? Or did the common law consist only of the body of rules administered by King's Bench, Common Pleas, and the Court of Exchequer? Were Acts of Parliament included within the common law? Did the common law require its adherents to administer substantive rules of law, or was it merely a set of procedures adumbrated in various writs and forms of action? Over time, some of these questions would be resolved. But in the late 17th and early 18th centuries, when authorities in England were demanding adherence to the common law, those authorities never defined precisely what law they were imposing. As a result, although every colony had to grant some degree of governance power to lawyers, each colony had a good deal of freedom as to what elements of the common law itself the colony accepted. Still, the process of reception, in the end, transformed radically diverse legal cultures into a coalescing, albeit variegated, system, but a system in which lawyers had weighty influence everywhere. Part 3 addresses the third theme of the volume, the unfolding and maturation of localism. As Part 3 shows, the Crown faced pushback to its efforts to impose common law, as many localities sought to govern themselves in their accustomed, diverse ways. After the Glorious Revolution of 1688 to 1680,